Good morning, good afternoon. Thank you very much for joining us today for Hunton Williams webinar on the SEC's Cybersecurity Guidance. I'm Lisa Soto, and I head Hunton Williams' Global Privacy and Cybersecurity practice. Before we begin the program, I'd like to note that our program is being recorded and we'll provide everyone with a link to listen to the recording at a later date if that interests you. If you have questions throughout the program, please use the chat feature on your screen. You can type in your questions, and if we have time, we will certainly address your questions at the end of the program. I'd like to introduce our all-star speaker cast for today's program. I'm delighted to introduce my partner Aaron Simpson, who is resident in Hunton's London office. Aaron leads the firm's European data protection practice, and he has over 15 years of experience advising clients on a broad range of privacy, data protection, and cybersecurity matters. And Aaron has been recognized in his field by Chambers, Computer World, New York Super Lawyers, and the Legal 500. Also joining us for today's program is Scott Kimple. Scott is a partner in our Washington, D.C. office, and he has in-depth knowledge of SEC policies, procedures, and enforcement issues. Scott regularly advises clients on matters involving securities laws, M&A matters, corporate governance, and regulatory enforcement. And prior to joining Hunton, Scott served on the executive staff of the SEC as counsel to Commissioner Troy Paredes from 2008 to 2012. And finally, I'd like to introduce Brittany Bacon. Brittany is a senior associate in our New York office. She routinely advises clients on data breach and cybersecurity incident response. And Brittany has advised on a number of the very biggest cyber incidents globally, and also handles a myriad of proactive cyber readiness projects. So to just introduce the program today, the highly pernicious nature of today's cyber environment hasn't escaped anyone. And the SEC certainly has stepped up its focus in a big way in recent years on this issue. And I would venture to say that the SEC has now taken its firm place among the U.S. regulators that are steeped in this area and that are regularly now investigating and enforcing in the cybersecurity space. It's now been a number of years since we saw any guidance from the SEC in this area, and as Scott will tell us, he'll give us the historical background as well as take us up to the present. The first official guidance was a staff guidance issued in 2011, and this time the guidance was issued by the Commission itself, which is really quite notable. I think it's hard to underestimate the significance of this pronouncement to virtually every issuer. It really is a critical document, and we're very happy to try to shed some light on it today. We're going to cover today in today's program the general quick overview of the cyber threat landscape. You all know it very well, but just to make sure we're all on the same page. Scott will give you some background, some historical information about where the SEC has been on this issue, and take us through to today, talk a little bit about the impact on issuers. And then Brittany will hit on some recent SEC enforcement actions in this space. Aaron will talk about the GDPR and the Network and Information Security Directive, which is so critically, these are two critically important pieces of legislation in the EU and driving so much of what we do in the cyberspace now and certainly going forward. I will hit on a little bit of the role of the board in cyber governance, and we'll talk about some proactive measures. How can we try to mitigate the risk if the worst happens? Next slide, please. Okay, can we get the map up? So what is populating here, and this is a bit of a difficult slide, but it's a great visual. You can see on this slide, this is the Norse attack map, and we see events actually happening right now. There are honeypots placed all over the world, and so we're seeing live attacks, and you can see, if you can read, this very small, but you can go into it yourself later to see it, but you can see the number of attacks coming from first China is first on the list, and the targets, the U.S. is first on the list. So this is really a tremendous way of sort of understanding that attacks are happening just constantly, every minute of every day, and we are fending off the intruders on a constant basis. Please. This is a clear indication of the fact that there is no industry sector that is exempt from this threat. We see on this slide representatives from financial services, from the technology sector, healthcare, retail, government, and then there are those attacks that don't discriminate at all by company or industry sector, and that hit far and wide, like WannaCry and NotPetya. Ransomware attacks that hit hundreds of thousands of companies all over the world in many, many, many countries. These events have really served to focus the attention of the C-suite and boards on cybersecurity. There's little question that this is an issue that is named, if you ask any board, just about any board anywhere, first or second, probably first in their list of concerns. Why is that? Because there have been, aside from the huge danger and damage that has been wrought by these events, there have been a number of CEO resignations as a result of these events. So, for example, in Equifax, Ashley Madison, the Office of Personnel Management, and Target all had their CEOs resign as a result of cyber incidents, or at least in part as a result of cyber incidents. And boards also are threatened with ouster. So in Target, the Target board, for example, had 7 of 10 board members threatened with ouster. And boards have also been the target of derivative claims, and I'll talk a little bit about that. So that certainly, these events certainly serve to focus the eye on these issues, and these issues, are very much on the at the top of the radar screen. Next slide, please. So, who are the threat actors? We really think about 3 categories of actors. First, traditional hackers, those who are in it for pecuniary gain. They're seeking information that they can grab and sell on the dark web, and they're purely in it for the monetary advantage. The second, and we're seeing a lot of this these days, is our nation-state attacks, also known as advanced persistent threat attacks, APT attacks. Very virulent in today's landscape, and nation-states are going after just about any type of data that is meaningful to them from an espionage perspective, but also from an intellectual property perspective, to get some certain industry sectors jump-started in their own countries. So it really is quite a dangerous environment on the nation-state front. In addition, we are seeing still attacks by hacktivists. And when I say we at Hunton are seeing these, some of these are not making the news. Many of them are not making the news, so you're not reading about them, but we are handling them constantly. Every day we have 3 to 5 breaches on our plates, maybe more, and at various stages. And we are seeing a huge variety in the level of sophistication and also the creativity of hackers. And one thing that we can promise is that if you have a dedicated intruder who wants to get into your system, they will get into your system, period. And the only thing that we can try to do is make sure we in industry, in the private sector, is to try to make sure that we're identifying them as quickly as we can in our system so that they can do as little damage as possible. The data that is now at issue by these intruders really varies. We are far beyond the world now where personal information was everything and all that was being sought was personal information. Now we're representing companies that are suffering from attacks on source code, on network diagrams that are being sucked out of their systems, router configurations, as well as financial data, M&A information. And we're also seeing cloud environments hacked. And that means that the information that is taken is really varied because companies put sometimes just a huge amount of data in the cloud, and that data can of course be accessed and has been, and we're representing a couple of companies unfortunately that have had their data hacked in a cloud environment. How are the attackers getting in? Well, the FBI tells us that 90% now are getting in through social engineering. Social engineering, of course, preys on human weakness and the desire of humans to please or act when asked. And there's nothing wrong with that. It's what we do, and it's the way we interact with each other. But there are malevolent parties who are looking to prey on those weaknesses through phishing attacks, through quote-unquote help center calls asking for remote access into your system. There are many, many ways that the intruders are getting in through social engineering. What we're seeing a lot of now are attacks such as doxing, which is pulling everything an attacker can about an individual, and usually senior executives and their families through the internet. There's a huge amount of information available, of course, and then using that data to make veiled threats. And they typically don't cross the line into illegal behavior, but it's really frightening for the executives, and sometimes we need to deploy security details to protect them. We're seeing a ton of wire transfer scams. Companies are being scammed for very significant amounts, often 1 million, 2 million going out in one pop to an ostensible vendor, and of course it's not the real vendor. It's a wire transfer to a fake account, and within 24 or 48 hours it is untraceable and you can't get it back. So that's money lost. Ransomware continues to be rampant. Even when data is not actually taken from systems, it's locked up. And if it's critical data to the company, if it's really vital to operations and backups are not available or are corrupted, can't be restored, then the company is really at a loss. And sometimes companies pay, sometimes companies don't pay. It's very, very much fact dependent. We're also seeing a lot of cyber extortion. Where senior executives are being extorted for significant sums when attackers have the data and say, for example, that they won't announce that they do, or they'll give it back. Of course, we can never trust that they'll actually give it back and then not use it again. And we're also seeing an uptick in e-commerce threats because now that our point-of-sale environments have gotten more secure using chip, EMV tools, then now we're seeing a move toward e-commerce. But I will also say we're still seeing skimmers on point-of-sale devices. So the old-fashioned way is still there and still working its magic, and the attackers are doing quite well still with the old-fashioned methods of stealing data. Next slide, please. And Scott, I'll turn it over to you.
Thanks, Lisa, and again, welcome everyone. Just thought we'd start by going through some of the history behind how we got to the guidance that was issued a couple of weeks ago by the SEC. I think there's this misconception that the SEC is a relatively new player to the game, and while it's true they've been ramping up some of their rhetoric and some of the formal guidance in recent years, they've really been confronting cyber issues since the mid-'80s when the Edgar initiative began. I mean, nowadays every public company makes their filings through the Edgar online system. That's been the case really since the mid-'90s. But that's a process that started in the '80s at the SEC. And even back then, I mean, the world was obviously much different. They're having to confront the issues about having a system in which sensitive and secure information has to be transmitted from one party to another. It's kind of a fun little thing now to talk about the Y2K bug and how quaint that seems by modern standards. But for those of you that were around working back in those days in the mid-90s, it was a serious issue, and we all thought that on January 1 the world was going to come to an end, or at least we'd be living in caves or something. And so, not unlike the current system now, the SEC staff issued a series of pronouncements culminating in a staff legal bulletin that was jointly issued by several divisions, informing SEC registrants how to go about discussing these issues so that investors would be on guard. And that's largely the same process that the agency has taken more recently. The other interesting development in the late 90s was the development of this thing called the Internet, which now again seems as commonplace as anything else. But when it first came out, it was this newfangled kind of technology, and anytime you have a new technology, it provides a great opportunity not just for good, but also for the scammers and the fraudsters to come out. And the SEC staff realized that there was a higher incidence of scams involving online issues. And so they developed in 1998 an Office of Internet Enforcement, which unfortunately was disbanded just a few years ago, but at its peak had really become kind of the SWAT team at the SEC for investigating online and cyber issues. And during the time that office was in operation, they developed a whole host of investigative methods and techniques for tracking down online scammers and fraudsters, including some very sophisticated techniques for tracking anonymous and pseudonymous actors. That office may have been disbanded, but a lot of the learning and knowledge it acquired has since been spread around the rest of the Division of Enforcement. It really wasn't until 1999 when Congress passed Gramm-Leach that the SEC started writing formal rules on data privacy. And Lisa's going to talk some about Gramm-Leach later. There, though, we sort of have this tale of two cities. So you have Gramm-Leach and some subsequent legislation, and the SEC's approach to data privacy has sort of been different depending on who the regulated entity is. For broker-dealers, investment advisors, registered mutual funds, those kind of entities, the SEC has passed a whole number of rules, including the safeguards rule under Gramm-Leach and various other regulations. And that's because the SEC has the substantive authority to regulate those entities. For your sort of run-of-the-mill public company, the SEC historically has not had any authority, and it's probably a good policy decision for the SEC not to have that authority to get into micromanaging operations. So what the SEC has instead done over the years is use the power of disclosure. If we can't regulate the substantive operations of a business, we can at least make them disclose information to investors that we think is important for those investors. And that's how we got to the first round of cybersecurity guidance that came out in 2011. This was a staff document. It was issued by the SEC staff, not the Commission. We'll talk about the significance of that in a moment. And it went through a series of issues, risk factors, MBNA, et cetera, for where areas that companies should consider making disclosure to investors. It's a relatively short document. By today's standards, somewhat unsophisticated, but it still provided a preliminary roadmap for the issuer community to understand what some of their disclosure obligations are. It also got into some timing issues in terms of when is it appropriate to update information, when is it appropriate to not disclose certain information, and for the first time it also broached the subject of disclosure controls and procedures. It's interesting because when we get to the 2018 guidance in a moment, you'll see that all of these topics are revisited in much greater detail. Of course, it was a staff pronouncement. Almost immediately, the SEC started withering some political criticism from the Hill that, look, this is great, but the commissioners themselves should really weigh in on this issue. And also a whole number of institutional investors over time, and certainly in the last few years as ESG issues have become very popular, have been saying, look, we want to know more about cyber risks at our portfolio companies because we've gotten to the point where these are the sort of things that could bring down the business. And so it's no longer just kind of a curiosity on the side. These are mission critical. They affect daily operations and governance of our companies. The next slide, please. So we remember we had an election not too long ago. There's a new presidential administration, and as customary, there's a new SEC chairman. Jay Clayton comes into the SEC. He's a person who had practiced at a large law firm for many years before coming into government, had some direct cybersecurity experience, perhaps knows the space better than some of the previous SEC commissioners. And right after he gets to the SEC last summer, it's disclosed that the SEC's Edgar system itself has been hacked, and some threat actor for some unknown period of time had access to non-public information before it was posted to the public side of the Edgar database. So a little bit of egg on the face. It happened under a prior administration, prior SEC leadership, but it still didn't look good for the SEC out there while it's trying to do all its cybersecurity enforcement to itself be the subject of a significant event. So a few things came out of that. One was the creation of a cyber unit in the Division of Enforcement. We'll talk about that some later. But also the agency as a whole reconsidered whether it was appropriate for the commissioners themselves to issue some formal guidance on this topic. Not too long ago, we got back up to full strength at the SEC. For several years, they've been operating at less than 5 commissioners. But now the Senate has confirmed everyone, and so we've got a full complement of 5 commissioners. It's a bipartisan body. So it was a great time for the agency to speak. And so what is the relevance of commission interpretive guidance? Why is that better than staff guidance? And like most agencies, the SEC staff regularly release all kinds of information to regulated parties to provide insights into the way the staff views issues of importance. No action letters, interpretive letters, compliance and disclosure interpretations, the list goes on and on. And to a regulated entity, that's kind of the law. The agency's staff said we should do it, so we're going to do it. And as a practical matter, that's generally true. Where it becomes important is when you start looking at the level of judicial deference that is given to agency actions. And as a practical matter, staff guidance, staff rulings, staff interpretations are entitled to absolutely no judicial deference. And when courts do occasionally confront the weight that an SEC staff pronouncement should be given, they typically say, that's interesting, good to know, but I'm the judge here and I'm going to decide what I want to do. Not so much the case, though, when the commission itself speaks. And so I think we're all probably familiar with the Chevron case, which gives, under most circumstances, agencies, as between agencies and judges, it gives agencies the upper hand to determine what pronouncements from Congress mean. There's a similar doctrine that applies to administrative agencies, not when they're interpreting a statute, but instead when they're interpreting their own regulations themselves. There's a 1997 Supreme Court case called Auer that builds on a 1945 Supreme Court case called Seminole Rock. So sometimes it's called Auer deference or Seminole Rock deference. And what it basically means is that agencies have the highest level of deference when interpreting their own regulations. So that means when the 5 SEC commissioners get together and issue a formal pronouncement, it has basically the same weight as law. Unlike other kinds of guidance that the agency may give through its staff, when the 5 commissioners jointly speak on what a particular regulation means, the courts will respect that. There is an outer boundary. We still have the Administrative Procedure Act. There still has to be notice and comment rulemaking for new pronouncements. You can't use interpretive guidance to announce new law or new policy. What you can do, though, is the agency can interpret its own rules and say, look, we've got some rules on the books. Here's how we're officially interpreting them. And again, courts will give that guidance a very high level of deference. That's what we have here on the guidance that the agency issued a couple of weeks ago. And I think, again, it's important because this is really the first time that the 5 commissioners have, as a whole, weighed in on this. Many commissioners and the SEC chairman himself have been giving speeches for some period of time about what they think the law is and how they'd like to see companies operate. But until all 5 get together and take a formal vote, it's not official. Well, now it's official. So what does the guidance do? That's a big part of why we're all here today. And it goes through a series of areas. It starts with the materiality inquiry, and that's really where any question under the federal securities laws begin. There's a well-established line of cases, TSC, BASIC, etc., that securities lawyers are familiar with, and many others as well. And what those cases basically say is when you have a reasonable investor, not a special interest investor or not some investor with special technical knowledge, but a reasonable investor, when they're looking at information, if there is particular information that is important enough to them that it would change their voting decision with respect to the security they hold, or if it would interest them in buying, selling, or holding the security, then that's probably material. And so securities lawyers all the time make these fine distinctions about what's material, what's not. It's a concept that appears in other areas of the law. There's a similar but not identical concept under GAAP. And it's also a term that means different things in different countries. But in the U.S., that's the basic standard. And so the SEC's guidance goes through the materiality analysis in the cybersecurity context, and it repeats a lot of the same kind of themes that I just discussed. And another big one is when you're talking about future events, you have to weigh the probability and magnitude of the event. And the more probable it is and the larger the magnitude it is, then the more likely it is you have to disclose it. The guidance kind of takes you through that analysis. And in particular, it emphasizes that when we're talking about cybersecurity risks, they depend on their nature and probability and magnitude as those things relate to any compromised information or the business and the scope of the company's operations. And it also depends on the range of harm that an incident could cause. Companies on a daily basis, as Lisa suggested, are being attacked. Not all of those events are material, though. So we have to just, for purposes of the securities laws, consider what is. And there could be certain kind of harms unique to companies because of the cyber risk. That can include reputational harms. It could be impacts on financial performance, customer-vendor relationships, possibility of litigation, regulatory actions, those sorts of things. This is really the first time the Commission has spoken on the materiality issue in the cyber context. Importantly, they also said, look, we realize that this is a sensitive area. Just because an event is material in the cyber world doesn't mean you have to disclose all the gory details. We don't need to provide a roadmap of technical information that would allow a threat actor to act on that and move forward and cause even more harm. But by the same token, the agency also said, look, just because you're in the middle of an investigation or just because this is something that's very sensitive or proprietary doesn't mean you get a free pass not to disclose it either. If it's material and it trips one of our other disclosure requirements, you very well may have to talk about it. One thing that the guidance didn't do, and this goes back to my earlier comment about the SEC can only interpret existing regulations, it can't announce new things through interpretive guidance. The guidance does not create an 8K obligation. I think there was a lot of rumors in some of the technical press that was coming with this guidance. And I think folks that understand the SEC and administrative law would say, well, that's silly. You can't use guidance to create an 8K obligation. That would have to go through notice and comment rulemaking. But there is a movement, and we'll talk in a moment, to create an 8K reporting event for certain materiality or certain material cyber breaches. Such a trigger does not currently exist, but it wouldn't be surprising to see future rulemaking on that issue. So we'll stay tuned for that. Another area that the guidance discusses are a whole host of substantive disclosure items under Regulation SK. So, those of you that are accustomed to putting together SEC reports, it's sort of a menu that you go through, and there are objective factors that you have to consider. The guidance goes through risk factors, for example, and says, look, these are some of the kinds of risks that you should consider, and there's a laundry list in the release. Some of them include the occurrence of a prior cybersecurity incident and its severity and frequency, and others include the probability of a future event, the cost that could go to it, the potential for reputational harm, etc. There's also a discussion, I think this is very important, when drafting risk factors, not to rely on boilerplate. And this is something we see a lot when we work with companies, where they talk about cyber risks as some sort of metaphysical thing that may happen in the future. And one of the first questions we have is, well, have you had one in the past? And it's unusual for the answer to be anything other than yes nowadays. So you can't just talk about something that's happened in the past as if it's some hypothetical thing that could only happen in the future. That's something that the SEC enforcement staff, when they're looking to bring an enforcement case, will look at. It's something private litigants will look at. Because what they're trying to do is say that the risk factors themselves were just mere boilerplate, and they didn't sufficiently address whatever the issue was and put people on proper notice. So one of the things to keep in mind when you're drafting a risk factor is, look, if you've had events in the past, and virtually everyone has, you have to keep them in mind and contemplate them in the risk factor. It's not enough just to talk about these things hypothetically, theoretically, as if they could happen in the future. Another area that the guidance discusses is MBNA. This, as we know, is the area where the SEC in the past has said, tell us about the business and its operations and its finances through the eyes of management. And so there are a number of different areas in MBNA where cyber events and cyber risks could be impactful. Again, laundry list in the guidance, things like the loss of intellectual property, costs of maintaining insurance, costs of responding to litigation, costs of engaging in remediation, addressing reputational harm, loss of competitive advantage, etc. Keep those things in mind as you're drafting MBNA. Under item 101, the description of the company's business, there's some brief information about other risks to consider, and in particular how a cyber event could impact the company's products, services, relationships, etc. There's a section on legal proceedings that companies are required to discuss in periodic reports, and the SEC's guidance reminds registrants that, look, cyber litigation, if it ticks the other materiality boxes, might be something that you also have to discuss. These could impact financial statements. That's more a GAAP question than a legal question. But there are different areas the guidance discusses in terms of things that could either run through the P&L or the balance sheet, or that may require footnote disclosure, and even it may require segment disclosure. So the guidance has some of that in it. There's also a relatively new item. This was adopted when I was on the staff under item 407H, which requires a discussion of board risk oversight. That may be relevant here, the SEC says, and Lisa is going to spend a lot of time at the end of the presentation today talking about some of the things that boards and management can be doing. Those sorts of things would be very relevant for this kind of disclosure. There is also some discussion in the guidance about the duty to update and the duty to correct, which again is sort of an esoteric area for securities lawyers, but it provides a little bit of guidance. And those are generally separate obligations, the duty to correct and duty to update. The duty to correct tends to apply to information that the company has put out in the marketplace that's no longer true due to the passage of time or some other factor. The duty to update is for things that maybe you haven't talked about so much or that have become stale over time. And in that case, the SEC reminds registrants that now would be a good time to revisit or refresh prior disclosures. And again, the SEC always issues boilerplate. So, my experience with a lot of public companies has been that some boilerplate disclosure gets drafted and it ends up in a 10Q or a 10K, and then nobody really looks at it for a couple of years. And every third or fourth year, someone says, well, there's been enough passage of time since we looked at this again. Maybe we ought to update this. I think what the SEC is really saying here is that's not going to be frequent enough. You need to be doing this on kind of a real-time basis. Disclosure controls and procedures is also a very important area. And I think there are parts of the guidance that resonate to lawyers that are like we are in the midst of enforcement matters, because some of this is based on non-public issues. But this is one in particular where I think the SEC is learning from what it's seeing through the enforcement process to say, you know what, there's a lot of information that's happening at lower levels that's being collected in businesses, but it's not trickling its way up to senior management. It's not trickling its way up to the board, and there could be lots of different reasons for that. But the guidance reminds companies that, look, cyber risks, cyber incidents, disclosures that may come out of those, that's like any other piece of material information. And so as you're constructing disclosure controls and procedures, as you're operating your disclosure committees, as you're generating other internal information and trying to decide what bubbles up to the C-suite and what bubbles up to the board, the SEC is reminding companies that, look, cyber stuff is the same as any other material disclosure, and you need to consider it. Another area that the guidance touches on is insider trading risk. And this is sort of interesting because, again, this is kind of a grab from the headlines sort of issue. There have been recently a number of high-profile data breaches at public companies where the intrepid reporters have been doing what they do, and they've been finding correlations between trading in company stock by C-level executives and the public disclosure of an event. And usually the trading has happened before the disclosure of the event. Creates the impression, at least to the public, that perhaps these executives knew something, were expecting there to be a fallout, and so they wanted to buy or sell stock before the rest of the market knew that. That sort of thing, of course, is classic insider trading. The insiders hold a duty of trust or confidence by virtue of their positions, and when that is true, the basic rule of you cannot trade on the basis of material non-public information applies. The SEC goes through some detail to say, look, that applies to insider trading in cyber issues. It's no different than knowledge that the quarter is going to be good or bad, or that a significant transaction is on the horizon, or that a key supplier is having financial difficulty. Cyber information is the same kind of material information as every other category that goes into the insider trading analysis. And so companies need to be aware of that, and they need to reconsider, to the extent they have insider trading policies that don't address cyber risks, to address those risks. Finally, the guidance goes a little bit into Regulation FD compliance. Honestly, I haven't seen this as much of an issue, but I think what the SEC is getting at there is there's sort of this parallel world when a breach happens, and it's getting a lot better. But in the past, what's happened is the public relations machine goes into overdrive, and admittedly, under a number of different statutes outside the SEC, there are notification requirements, there are requirements to notify regulators and customers and those sorts of things. But companies also sort of go into the public relations machine and start providing information really designed to make customers and suppliers comfortable, and it's not really designed to be information transmitted to investors. The SEC looks at that and says, wait a second, you're out there on a daily basis giving press conferences and doing press releases, and you're not putting that information into your SEC reports. Now, maybe that information is not material to investors, but to the extent it is, you do have that obligation under Reg FD not to provide selective disclosure. So, I think the trend has changed recently so that a lot more of these things are being done in a Reg FD compliant manner, but that's one more thing to keep in mind. Now, the notable thing about the guidance is that the Commission was unanimous in adopting it. But we did see two statements issued by the two Democrat commissioners, Commissioner Stein and Commissioner Jackson, that were slightly critical of the guidance, and critical in the sense that both took the view that this is great, we're doing something, could have done a lot more. And Commissioner Stein in particular goes through a number of areas where she says she would have liked to have seen the SEC engage in rulemaking and get that process started. Again, you can't use guidance to announce new rules, but this could have been an opportunity for the Commission to start that process. And I think it's helpful just to quickly mention the four things that she thought were important, because this may preview future action by the agency. First, she would have liked to have seen a proposal on rules that address improvements to board risk management and the framework related to evaluating cyber risks and threats. Second, she would have liked to have seen minimum standards to protect personally identifiable information of investors, and whether such standards would have been required for other market participants like broker-dealers and investment advisors and transfer agents. Third, she would have liked to have seen an 8K requirement that would have required companies to provide notice to investors on 8K following a cyber attack to provide disclosure that is useful to them, trying to balance that against providing competitively harmful information. But as with so many other areas where there is a special 8K disclosure item that would require disclosure outside the normal cadence of your Qs and Ks, she would have liked to have seen an 8K on that. I personally think that's something the SEC will give a lot of thought to, and 6 or 12 months from now we may be talking about a proposal just on that, so stay tuned. And finally, and this was a little bit more ambiguous, but she would have preferred the SEC to have another set of rules that were much more programmatic, and that would have required public companies to develop and implement cybersecurity related policies and procedures beyond mere disclosure. That perhaps is the most provocative of the four suggestions, because again, it gets you into this territory where historically the SEC has not regulated the substantive operations of public companies. I think there's a good legal argument that they don't have the authority to go that far beyond the disclosure stick and carrot. But this is an area that Commissioner Stein, I think, would have liked to have seen more action on. And again, it's quite possible that the agency will consider all of these things in the future for future rulemaking. We'll just have to wait and see. Next slide, please. So a few quick takeaways, and a lot of this feeds into some of the things that Lisa and others are going to talk about in the remaining part of the program. But first of all, management and the board, it's very clear now, must have a disclosure framework for cyber issues. There's got to be a process in place, and again, to make sure that information that may reside right now just in mid-level management or with technical experts, whether it's the director of IT or the information security officer. That information has to get up to management and the board, and you need to have a process around that. I think the second area is around disclosure controls and procedures. There's quite a bit of discussion in the release about it, really suggesting that companies need to beef up those policies and procedures to address the disclosure risks that come with cybersecurity events, and to make sure that they're actually being disclosed on an appropriate time frame. More generally, other policies and procedures should also be looked at. I discussed insider trading. That's one where most companies have an insider trading policy that goes into at least how insiders, be they employees or management, have to address trading, trading windows, blackouts, more general policies. It's probably a good idea to dust those off and take a look to make sure they address cyber issues now as well, in the spirit of this guidance. Always be refreshing and revisiting your disclosures in your periodic documents and your periodic disclosures to investors, but especially now in the light of this guidance, now is a good time to do it. It's curious, the guidance came after most companies had their 10Ks ready to go, but certainly in time for your first quarter Q in the next month or two as those disclosures start coming together, really go through the guidance carefully and make sure you've addressed all the points. I think the final thing I'll hit on is the formation of the cyber unit in the Division of Enforcement. And this is sort of the successor in an indirect way to the Office of Internet Enforcement that I talked about earlier. So just a quick note on specialized units more generally at the SEC. This is a topic that sort of came into vogue in the sort of 2009, 2010 timeframe. Again, we had another presidential election then and a different management team. And the SEC was still smarting from kind of the 1-2 punch of both the financial crisis and the revelation that the agency's staff had missed the Bernie Madoff fraud, and to a lesser degree the fraud involving Alan Stanford. And so the approach taken by the Division of Enforcement and its then head, Rob Khuzami, was to emulate what the U.S. attorney's offices in some of the larger federal districts do, and instead of having generalists, to create special task forces that have subject matter expertise in particular areas. The SEC set up a number of these at that time, didn't do one on cyber, and it's just kind of a quick footnote. After Rob Khuzami left the SEC to return to private practice, he heard the siren song of government again very recently, and he's back in the government now, back in the Southern District of New York's U.S. Attorney's Office, where he's basically the acting deputy director. So we'll see more of him, I think, on the criminal side with these issues in the near term, but that's just a footnote. So as I said earlier, we had the new SEC chairman, Clayton, come on board about a year ago. We had the revelation that Edgar had been hacked, and we had then the announcement in September of this year that the SEC was forming a cyber unit in the Division of Enforcement to focus on these kinds of issues. And so just a quick note on that, and we'll continue with the rest of the program. The leader of that unit is Rob Cohen. He's a longtime SEC veteran who most recently had headed another unit, another specialized unit, the Market Abuse Unit at the SEC. And as he put together the cyber unit, he pulled on a lot of folks who had background there. So he's now put together a team of about 30 enforcement attorneys throughout the various SEC regional offices, as well as in the Washington home office. And again, many came from the Market Abuse Unit, where they were spending a lot of time investigating algorithmic trading and frauds against broker-dealers, et cetera, that involved cyber issues. So a lot of his team already have this kind of background. They have expertise in cyber trading, detecting fraud. They've been busy very recently with initial coin offerings and token offerings, different issue, but again, it's one that's based on a new technology. This time it's blockchain distributed ledger technology. And Rob and his team have developed special techniques and tools for surveilling not just the lit web, but the dark web, where a lot of activity happens. And they're very good at tracing the identities of threat actors who seek to operate anonymously. They're also spending a lot of time partnering with other government agencies, not just the usual suspects like the Department of Justice, and their peers in criminal law enforcement, but other agencies that deal more specifically with cyber risks, Secret Service, FBI, DEA, folks that the SEC has not as frequently cooperated with or worked with in the past. But now this is all part of the government's effort to attack these issues. So from there, I'm going to turn it back over to Lisa to go back to talking about some of the more specific SEC enforcement actions that we've seen in the last few years.
And Brittany, I think you're going to take that.
Yes, thank you. Thanks, Scott. Thanks, Lisa. So to provide some context based on historical precedent, the SEC has brought only a handful of enforcement actions in connection with data breaches and cybersecurity incidents on the basis of a finding of a GLB violation, specifically Regulation SP. Regulation SP and Rule 30A in particular requires every broker, dealer, and investment company and every investment advisor that's registered with the Commission to adopt written policies and procedures that address administrative, technical, and physical safeguards for the protection of customer records and information. These written policies and procedures must be reasonably designed, 1, to ensure the security and confidentiality of customer records and information, 2, protect against any anticipated threats or hazards to the security or integrity of customer records and information, and 3, protect against unauthorized access to or use of customer records or information that could result in substantial harm or inconvenience to any customer. Notably, these enforcement actions were not brought on the basis of a failure to disclose an incident. And based on the Rule 30A that I just read, there's no indication that notification or disclosure per se is required. Rather, the enforcement actions were brought for a failure to maintain policies and procedures that were reasonably designed to protect client data. In the most recent Reg SP case back in September 2016, Morgan Stanley agreed to pay a $1 million settlement with the SEC as a result of an unfortunate insider incident that the Commission had tied to a failure to adopt written policies and procedures reasonably designed to protect customer data. Prior to this action, there were 6 other Reg SP cases that similarly found an alleged failure to maintain policies and procedures designed to protect against reasonably foreseeable risks. These actions were brought against smaller and less prominent firms that had similar issues. Just by way of example, in the RT Jones case, which predated the Morgan Stanley settlement back in 2015, RT Jones' third-party hosted web server was attacked by an unauthorized intruder who had gained access to the server that contained data of more than 100,000 individuals, including SSNs. The SEC found that the firm had failed to adopt any written policies or procedures reasonably designed to safeguard client data. And specifically, the SEC found that the policies did not include requirements to conduct periodic risk assessments, to employ a firewall to protect the web server containing client data, to encrypt client data stored on the server, or to establish procedures for responding to cybersecurity incidents. Prior to that, there were a number of other Reg SP enforcement actions. One of the first against Next Financial Group related to an incident where Next permitted registered representatives to take client non-public personal information with them when they left their employment with the firm. The SEC found that Next did not have policies and procedures designed to prevent this disclosure of client non-public PI by registered representatives to successor brokerage firms, even though that firm knew or they were alleged to have known that there was a reasonably foreseeable risk of this occurring. Importantly, the judge stated that Rule 30A does not in itself impose an absolute duty to ensure the security and confidentiality of client information, and an underlying incident does not automatically establish that a firm's policies and procedures were unreasonable. To establish a Rule 30 violation, the SEC found that considering the totality of the circumstances, a firm's policies and procedures have to be found to not be reasonably designed to protect client data, which the judge in that case interpreted to mean at least negligently. In each of these Reg SP cases, the relevant firms agreed to enter into some sort of agreement, whether it was a cease and desist order that barred the firms from committing or causing violations of the rule, and resulted in civil penalties that ranged from $15,000 to $275,000. We just wanted to mention two other interesting SEC enforcement cases, slightly different, that focused on fraudulent trading using hacked data. Specifically, Wilner in October of 2017, the SEC charged this day trader with generating over $700,000 in illicit profits as a result of a scheme to access the brokerage accounts of more than 100 customers and make unauthorized trades to artificially affect the stock prices of various companies. Wilner had allegedly traded in the same securities in his own accounts and took advantage of the artificial stock prices that resulted from the unauthorized trades placed in the victim's accounts. The SEC sought the return of the ill-gotten gains plus interest and penalties and issued a permanent injunction. The co-director of the SEC's Division of Enforcement said, account takeovers are an increasingly significant threat to retail investors, and it is exactly the type of fraud our new cyber unit, which Scott referenced earlier, is focusing on. Finally, in the Huong Case in December 2016, the SEC charged 3 Chinese traders in connection with fraudulent training on non-public information that was stolen by hacking into the networks of 2 law firms. The defendants allegedly hacked into the law firms by installing malware on those networks to steal confidential information pertaining to firm clients that were considering mergers and acquisitions. This gave the hackers access to all email accounts at the firms, including email that contained certain non-public information about the potential M&A. This allowed the attackers to use the stolen non-public information to purchase shares in at least 3 public companies ahead of public announcements regarding the merger agreements. The SEC charged the defendants with violating the anti-fraud provisions of federal security laws, and in May of 2017, the U.S. District for SDNY ordered the defendants to pay nearly $8 million in fines, disgorgement, and interest. Now I'm going to turn it over to Aaron, who's going to speak to the European landscape.
Thanks, Brittany. Shifting gears, while there's been substantial regulatory focus, obviously, in the U.S. on cybersecurity and breach notification, this is a more recent development at the EU level in Europe. It's not totally new at the member state level. More in places like the UK, where I live, the FCA and the ICO have been quite active for some time. But at the EU level, things are a little bit different. Notably, there's 2 important EU cyber regimes that are set to go into effect shortly that multinationals should be aware of. The first stems from the GDPR, which I'm sure everybody on this phone call has heard all about, the General Data Protection Regulation. The breach notification requirements in the GDPR are rather intense, meaning they apply to a broad range of incidents, and companies are required to notify regulatory authorities in a very tight time frame, typically within 72 hours of becoming aware of the incident. Personal data breach is the operative term under the GDPR, and it includes any breach leading to the accidental destruction or loss or unauthorized disclosure of or access to personal data, which is a very, very broad concept, as many of you probably know. Obviously, a range of different types of events could satisfy this definition and possibly require notice to regulators and data subjects. I say possibly because notice is not required to regulators if the breach is unlikely to result in risk to data subjects. Notice to data subjects, in turn, is not required if the breach is not likely to result in a high risk to data subjects. So the tables are turned a little bit vis-a-vis the U.S. In Europe, the default notice, if you will, is to regulators, and in some cases you must notify individuals, whereas in the U.S., perhaps you could say the default is to individuals, and in some cases you need to notify regulators. The harm thresholds in Europe under the GDPR are quite general, and how they're going to be interpreted precisely remains to be seen since the law comes out in May. Our guess is companies are going to see the potential fines for not reporting breaches in accordance with the law, and they're going to err on the side of reporting. That has borne out in a lot of different use cases in the U.S. as well as in various member states in Europe that have seen quite a few breach reports after laws have gone into effect. Note that if a third-party service provider has a breach involving your data, if you're the controller, if you will, in Europe, then the notification requirement still applies to the controller. The time period doesn't change, meaning that if the processor takes 60 hours from becoming aware of the event to notify you, then you have 12 hours to notify. The time period, there is no grace period. The regulators have made very clear in Europe that this notice issue should be addressed in the contract between the controller and the processor, so there really are no excuses that result from not knowing about a breach because a processor has not told you about it. Lastly, the GDPR will require companies to maintain a record of the breaches that they've had, and this record has to include breaches that do not meet the threshold as well as those that do meet the threshold, so that the regulator has a chance to see how you're doing in the decisions that you're making with respect to the breaches that you have had. Moving on, next slide please, the NIS Directive, the Network and Information Security Directive. This was enacted in August of 2016 in response to the emerging cybersecurity threat. The European Commission clearly recognized the cross-border threat posed by cybersecurity when they developed this. And importantly, when they enacted this, the member states were given 21 months to implement this directive into local law. This is different than the GDPR, which is a regulation, meaning it applies essentially uniformly across all 28 EU member states. A directive, like the NIS Directive, on the other hand, sets the floor, but the member states pass their own versions of the law. This directive does not apply to everyone, unlike the GDPR. It applies to operators of essential services and digital service providers. And there are essentially three goals for this directive. One is to establish a framework at the local level to address cyber issues. So member states are expected to come up with a framework to deal with these issues as they've done in the UK. Formalize cooperation across the member states on cybersecurity issues, and then it also imposes affirmative security obligations on the covered entities, including breach reporting obligations. The breach reporting obligations are different from the GDPR. They're not focused on personal data per se. They're more focused on confidentiality and things of that nature. But so there's a lot of issues where there could be a lot of breach incidents that could involve an overlap between the two. Almost like a Venn diagram, but there are also going to be breaches that companies that are subject to the NIS Directive need to deal with exclusively with their competent authorities or with DPAs at the member state level from a data protection perspective, but there will be some where they have to deal with both. With that, I'll turn it back over to Lisa to finish up.
Okay, thank you. And I have 2 minutes, and I'm going to use my full 2 minutes, but I promise we won't go over. The role of the board. So look, boards have absolute responsibility for overseeing information security practices of a company, and they are very much exercising their responsibilities in this space. This really started with Target when, as I said earlier, a number of board members were threatened with ouster. And the SEC came out with a statement with respect to cybersecurity incidents following the Target breach, and they cautioned at that time that boards had to focus on this, and and I'll quote here, that boards that choose to ignore or minimize the importance of cybersecurity oversight responsibilities do so at their own peril. So we know that there is real, we knew then that there was real focus, and certainly we know it now. There have been a number of derivative claims, the Yahoo case, PayPal, Home Depot, Wyndham. So there have been a number of them. Unfortunately, there is scant guidance in case law from these cases. There really are. There's very little. What we do know is that boards, from these cases, boards are required to provide appropriate oversight to the company's cybersecurity program. I think what we're seeing is that courts are rather hesitant to second-guess the board's risk-based decisions concerning cybersecurity controls. But certainly, the courts that have opined have hinted that an extensive board-supervised program is sufficient, a cybersecurity program is sufficient to defeat a claim that alleges that directors had breached their fiduciary duty to the company. Next slide, please. So it is critically important to prepare. The only thing we can promise you in this arena, and we work on a lot of this stuff, is that preparation will mitigate harm. It will. So preparation is key. Prepare, prepare, prepare. Make sure you have a state-of-the-art incident response plan. Make sure you've worked through tabletop exercises with your team over and over again. Build that muscle memory. Have state-of-the-art policies and procedures on information security. Have a data breach notification toolkit if you need one, an off-the-shelf resource. Make sure you're focused on vendor risk and insider risk. Very important to have a program around vendor risk and insider risk. Training and awareness is key, and make sure you're also assessing the state of your cyber security insurance. With that, I will wrap up and just note that there will be a recording, and please do visit our privacy blog at www.huntonprivacyblog.com for the latest in the world of privacy and cybersecurity on a global level. We look forward to having you at future events. Thank you very much for joining.